professionals from diverse sectors to engage in insightful discussion that will provide invaluable learning experiences for students and aspiring professionals. Today, we have an exceptional panel of experts who have made remarkable contributions in their respective fields. It is my privilege to introduce our esteemed speakers. I'm honored to introduce Ms. Ranjana Singh ma'am, a distinguished partner at KSN Partners, one of India's leading intellectual property law firms. With over 18 years of experience in patent prosecution, trademark enforcement, and IP strategy, she has been instrumental in advising clients across the diverse sectors, including technology, pharmaceuticals, and biotechnology. Holding degrees from IIT Delhi and TU Dixon, Ms. Singh combined her scientific acumen with legal proficiency, making her a leading authority in intellectual property law. A regular speaker at national and international forums, she is deeply committed to mentoring and fostering innovation. Please join me in welcoming Ms. Ranjana Singh ma'am. Now, we are honored to welcome Mr. Sajan Mathew, sir, Senior Vice President and Head of Legal at Federal Bank. With over 2 decades of experience in banking and finance law, corporate governance, and regulatory compliance, Mr. Mathew has played an instrumental role in shaping legal policies within the financial sector. His strategic legal insights have been vital in ensuring regulatory adherence and risk management in an ever-evolving financial landscape. A respected legal professional, his contributions continue to enhance the integrity of the banking sector. Please join me in welcoming Mr. Sajan Mathew, sir. Now, we are privileged to have with us today Mr. Sanjayan, Vice President at Legal at Reliance Industry Limited. With an illustrious career spanning 26 years across telecom, digital services, infrastructure, and renewable energy sectors, Sir has been at the forefront of legal strategy and corporate compliance. His expertise in policy development, risk management, and regulatory affairs has been instrumental in navigating complex legal landscape. A staunch advocate for corporate governance and ethical business practices, continues to shape the legal discourse in India. Please join me in welcoming Mr. Sanjayan. Now, it is my distinct honor to introduce Mr. Manish Lamba, sir, General Counsel at DLF Cyber City Developers Limited, with over 25 years of experience in corporate law, compliance, and litigation. Mr. Lamba has held prominent legal positions in leading organizations, including Bharti Realty, Bharti Airtel, and Coca-Cola. An active contributor to the legal fraternity, he has been a key participant in arbitration, corporate restructuring, and regulatory reform, serving on esteemed committees such as ASHOTU and the Singapore International Arbitration Center. His vast expertise continues to shape the corporate legal framework. Please join me in welcoming Mr. Manish Lamba. Now, it is an honor to welcome Mr. Avishkar Singhvi, sir, a seasoned litigation expert with over 13 years of experience in commercial and white-collar law. He has a graduate of UCL with a background in economics and business. He has a diverse practice spanning bankruptcy law, criminal defense, IP law, IT, tax law, and many more. As an independent practitioner, he has successfully handled complex legal matters and contributed valuable insights to the legal community, including features in Times of India. We are privileged to have him with us today. Please join me in welcoming Mr. Avishkar Singh. It is with a great privilege that I welcome Dr. Suni Augustine, sir, Associate Vice President and Head of Legal Land Acquisition at Adani Electricity Mumbai Limited, with over 26 years of experience in land acquisition, regulatory compliance, and environmental laws. Dr. Augustine has played a pivotal role in shaping legal frameworks for major infrastructure projects. His extensive research and contribution in policy development and legal reform have significantly influenced ethical land acquisition practices. An esteemed thought leader and mentor, he is dedicated to advancing legal scholarship and sustainable land use policies. Please join me in welcoming Dr. Suni Augustine, sir. Now, I would like to invite our Registrar Ma'am, Dr. Anuradha R. Tiwari Ma'am, Professor Dr. Jairam Sir, Dean, School of Law, for the felicitation of the panelists.
No, I'm just.
No, marketing team just told me right now. They want the camera to be stationed. Put it back.
Thank you so much, Avishkar ma'am and Dean sir. Now, to give us a brief about today's session, I would like to pass on the floor to our esteemed Dean, Dr. Jayaram sir.
Thank you, and greetings of International Women's Day. And this is one occasion where I feel that, because I will tell you, I'm an academician, who has turned professional turned academician. So I always find that there is a gap, there is a void between academy and the industry. And I'm really happy that we have few of the top professionals who are typical of their respective field. Career they have, experienced over the last few decades, and definitely this is one opportunity which is going to help our students to understand the gaps, and probably this is going to help you plan your academic journey and transition to the professional life. So I don't think I should be taking too much of time. We all are eager to listen to from all of you, eminent professionals, and this is something which is going to be an enriching experience for all our students. So, hearty welcome to all of you. Ranjana, Sanjayan, Sajan, Mr. Suni, Mr. Lamba, and Mr. Avishkar. So all of them amazing, and they're probably, I would say, they are the people who has been the highest experience, holding highest experience in the field of their respective areas of practice. And thank you for coming, joining us once again, and the floor is yours. I think the moderators can take it from here onwards. Thank you.
Thank you so much, sir. Now, I would like to invite the moderator of the today's session.
Good morning, everyone. I, Isha Singh, along with Professor Hina, feels honored to be the moderator of today's discussion at the Induslex Confluence 2025. It is a golden opportunity for us to engage with some of the most distinguished experts in the field of law. This discussion is not about abstract theories. It is about strategy, their execution, and impact. Today we have one of the most distinguished panel of experts with us present here today, who have navigated some of the most toughest and difficult legal battles, advised top institutions, and have framed many legal policies.
Good morning, everyone. Today is International Women's Day, and we have some leading women inspiration for us. And we are honored to have Ranjana ma'am on the panel. She's a dynamic woman who has led the way to become an equity partner in KS Department. Ma'am, we would like to learn from your life experience as to where exactly should we start, what should we do, and what should we do not do. Please, ma'am.
Yeah, so there are three questions. From where we should start, what we should do, and what we should not do. So I'll start with, am I audible? Okay. So what we should do. This was, or rather I can start with what and where we should start. So starting is never late, I can say. Jis din jago, usi din savera. But with saying that, it is always better to start as early as soon. Tomorrow never comes. As per my dictionary, today is the best day to start. And that also on the occasion of Women's Day, I can be more louder to say that today is the bestest day to start. I started my professional journey 21 years back, and I started as a teacher, which I wanted to become when I was studying in school. In fact, when I completed my graduation, till that time I wanted to become a teacher. But then during post-graduation, I came to know about the GATE exam. It's an engineering aptitude test. And after completing my master's in chemistry honors, I appeared for the exam. And I don't know how, but yes, my All India ranking was 44th and percentile was 98.34. I did not believe like that myself, but then because of the family support, friends and people like you inspired me that why don't you go for higher studies. This is how I ended up with doing my master's in polymer science and engineering from IIT Delhi. Then again my professors helped me to show me the larger picture of the world. And in that sense I can say that whether Dr. Jairam is too progressive and interesting that he's giving this platform to the students, learners I can say, it's a good connect to leaders to learners, that learners are getting this opportunity at this level. I got the opportunity to interact with such professors during my post-graduation time in IIT Delhi, and they inspired me to progress for the research. And there is a DART scholarship. It's an Indo-German exchange program. Certainly competition is everywhere. We were also, all over India IITs, only 50 students were to be selected for that DART scholarship. But again, with the mentorship of my guide and this thing, I was qualified too for that scholarship. And I did my part of my master's from Germany, Technical University of Dresden. So again, this is from where to start. So starting is, I don't know from where I started, but where I landed. So this is, and it's never late to when to start. But again, today is the best day to start. Completed my masters, came back. When during my IIT days, my passion developed for research. So I started my journey as a scientist with GE. I worked for 5-6 years as a scientist, and there I got an opportunity to meet the patent team, IP analyst of GE Research India. I was fascinated by the way the research they were doing, they helping the scientists to rule out the molecules which are already in the market. Because GE is pioneer in research and technology, they find new molecules to bring to the market, new and competitive molecules. And change is the only constant. So I was also impressed by the IP analyst of GE, with the flexibility they were having in doing the work. They can do work from anywhere, everywhere. Need not to enter into the lab or to go to regular courts, which we don't have that flexibility. In fact, I'm still maintaining that flexibility because I'm not a court-going lawyer. But I think these, excuse me panelists, don't be jealous of that, but still I am maintaining that flexibility with me that I can work from anywhere. And this brings a harmony between balancing the life, family and self. And this is how I started. Then I moved to law firm 15 years back. I joined as a technology, then as associate, senior associate, then partner, and now I'm an equity partner there. I appeared for the patent agent exam. And to be a partner in the law firm, one has to have a law degree and some experience of legal studies. So I completed my law and registered as a bar under the Delhi Bar Council. But my work profile is related to understanding the technology, drafting the patent application for our clients, for the researchers, for the institutes, and then doing prosecution to get the patent of that technology where big scientists, researcher, inventors are creating. So this is how I started, and how what I do is helping innovators to protect their ideas, their research, and giving the protection by filing their applications and then arguing the matters for that. In the legal aspect, we have core litigation team in the organization, and we help them in preparing the matters which they argue in front of the judge. So this is the part. What we should do. May I continue, or it will be
Please continue.
the dialogues and then so I should not take all the points, that this can
That's absolutely okay.
what we should do, we should be very sincere and honest with respect to what we are doing. That's the core thing with my experience of 20-25 years, I can say. Be honest, sincere, have passion, more hunger to learn more and more. The moment we become complacent, the growth stops. So that is the thing I always request the new generation, the learners, that never think that this is sufficient. Always, every day make a point that I should learn one thing new. In fact, I am so prepared that I am going to learn multiple things today, not only one. So that's the thing what we should do, consistent, and be honest to yourself, work hard, read daily, keep yourself abreast of the upcoming technologies. Whatever we have learned yesterday may not be useful today, but whatever we have learned will certainly help us today, but may or may not be with that pace, but yes. Learn every day, keep yourself abreast with the technologies, and what we should not do. Don't waste time on the screen so much. That's, try what you should not do. My only suggestion to the audience is, the learners is, your concentration should be undivided. Your attention should be undivided. Keep your phone cells away. Keep all your thoughts which are coming in your mind away. Even if you are opening your books, study books, or whatever you are doing for 30 minutes, that should be undivided. So whatever you do, do in a happy mood and with full concentration. Yeah.
Thank you. That's amazing. I would like to I specifically like the students to focus on the part that you do not need to use your cell phones all the time. Or the people who are using cell phones, please focus on the panel discussion.
Thank you.
So amongst the panel members, we have a veteran in the field of talk, Mr. Manish Lamba, and I would like you to share your life experiences with us, sir.
I'll give you a diametrically opposite view. I was not half as privileged as ma'am. She secured 98%. I could pass twice in those marks. So unlike ma'am, I cleared both maths and science. So I was left with the only alternative, which was arts. Commerce was also not my cup of tea. But I think what she said, that if you just keep on it and moving on and be little sincere, not completely also, and then you get an opportunity to sit here. 25 years ago I was sitting there. So I think I have had a checkered history, which is not a very good example. I was a late entrant into law. I was not a good student. but worked with great people, got great opportunities. The fortunate part or unfortunate part is that law cannot be taught, it can only be learnt. So the onus is on you. So my learning started late, but I worked with great minds. I started my career at the Supreme Court in Mr. Salve's chamber, and now I know many years later, he also, the gentleman on my right also joined Mr. Salve's chamber. Thereafter, I went to a law firm, worked for nearly a decade with a consultancy or law firm where I learned everything that I don't know of today. Then I moved to a company called Coca-Cola. Thereafter, I moved to Airtel Telecommunication, and now I work for a real estate company. So while ma'am was saying that, I was also taking a note that GE had a first venture in India called GE Plastics. That factory closed down. We built a swanky building on it known as DLF Cyber Park. I worked on the 9th floor. So before that, GE is known for its innovations. It started with Thomas Edison. So it is never too late. He became bankrupt, and I believe he made another patent at 64. He revived. So therefore, law has a very long journey. In 1857, something happened in India. Parallelly, something was happening in US. Women were fighting for their rights with respect to not being paid equal in the textile industry. And that's the reason we celebrate today on 8th March, the Women's Day. So, have I answered the question? So what I say is, while there is hope for the brilliant always, even mediocres who just keep to it do also get an opportunity to sit here. So there is nothing to worry.
Thank you so much, sir. So Isha, would you like to ask another question?
Yes, ma'am. We also have among us a highly accomplished professional, Mr. Sanjayan, sir, and I would like to request you to kindly inspire us with your life experience.
Hello. So, I started my career as a practicing lawyer. So 8 years I was into practice, then consultancy. So thereafter only I moved into corporate. So basically what I would like to highlight is that, see, I worked with organizations like ONIDA, GTL, Etisalat, and now with Reliance. So the transition from a practicing professional to an in-house counsel, so that changed my career path altogether, because that transition, if you look at it, it is not easy, because as a lawyer you are advisors, you are not standing on the shoes of the client. Here as an in-house counsel, you are as good as the client because you are answerable and you are responsible. The second aspect is that, see, from a learning perspective, I would like to say that, see, to work as an in-house counsel, you must have industry knowledge. Now that industry knowledge, you can, even how the industry works, you can gather that knowledge, start gathering that knowledge even today. Even by reading, if you are a regular reader of Economic Times or Mint, you will understand what is happening in the industry from a business perspective. Because, see, what a in-house counsel is doing is, he is applying the law on the given situations which, or incidents which are happening, which requires a legal solution. So the first part I would like to mention is that, See, we have to be strong in fundamentals. So the basics should be very strong. This I can tell you from my experience also, because a lot of Indians used to come to Reliance, and probably I would like to say that the understanding on the very basic things, even by the final year students, are not very good. So please ensure that your fundamentals are very strong. Then only you can move forward. The second aspect is that try to understand industry or how business works, because that is very important. Otherwise, your legal knowledge alone may not help you when you function as an in-house counsel. And if you have some industry knowledge on certain industries which you are working or advising, even if you are in a law firm, this will help you, a lot in understanding the client's problems in a better manner. So that's all.
Thank you so much, sir.
So again, amongst our panel members, we have a seasoned legal professional with an expertise in corporate governance, banking law, and policy development. I would like Sajan sir to please share your life experiences with us.
Good morning all. First of all, I'm wishing the happy Women's Day, and maybe the reason two lady moderators are here. I'm happy to join your team. And anyway, with respect to Ranjana, I'm joining Lamba sir's team, which I was also not that much as a studious student, as a moderate student. But actually, in India, or if you are pursuing that, a moderate or average student can also succeed in life. I'm not claiming that I'm fully successful, but I could do something. That is the opportunity before you. If you are pursuing for something, definitely you will reach somewhere. Maybe after 10, like most of these students, I also pursue with science. But then in between, I got understood that it is not fit for me. Then I opted for law. And after graduation also, I opted for human rights, specialization in human rights, and joined practicing before the Kerala High Court with much more enthusiasm to become an activist or to be a constitutional law lawyer. Then in between, within 1 or 2 years, I shifted to corporate side. Maybe because of the opportunities coming to us or through interactions and all from the corporate law. Then I joined banking side, and I could work in many areas in banking also, maybe recovery and strategy and policies also. Now I am heading the legal department of the bank. In banking industry, the difference between other industry and banking industry, because it is highly regulated, maybe all industries are highly regulated, and apart from the legal part, we need to deal with the regulatory part issued by the RBI also. There, the scope of interpretation is very less. In the statutory provision, we can interpret, we can challenge it before the court of law, but no bank is there to challenge and regulation issued by RBI. That is why we need to follow it rigorously, and there is little opportunity for interpretation. And it's a balance between regulation and interpretation in maybe regulations and legal provisions, that is banking. In fact, banking is a risky job, and the duty of the legal department is to bring a mechanism or bring a structure to balance the risk in the industry. And to my students, there are a lot of opportunity for legal aspirants in banking law. In HR, it is there, and in governance and compliance, it is there, and recovery part, it is there. That is the diversified areas of legal opportunities in the banks. As Sanjay told, we are also playing as an in-house lawyer. There definitely we need to get the industry standards. We cope up with the industry standards, the industry practices we should know, and as an in-house lawyer, we have accountability also. From my experience, I am telling that the opportunity is enormous, and if you pursue for something, definitely you will reach somewhere, and the sky is your limit. Thank you.
Thank you so much, sir. Thank you so much. I think majority of them has given us a very good inspiration to many of the students. That being a mediocre student is not a bad thing. You do not need to excel in it. Even if you are a mediocre student, you are going to achieve the heights. And sky is the limit. Isha, would you like to ask another question?
Yeah, next we have a young and dynamic lawyer inspiring right in the highest court of law, Mr. Avishkar Singhvi sir. I would like to request him to show some insights over his life experience and inspire us all.
Thank you for your question. My life experiences have been far too wide and deep to encapsulate in such a short period of time. But I'll tell you about my professional experiences. I started out like my esteemed co-panelist suggested, Mr. Sarve, who was far too big a giant at the bar at that time. And he in fact himself insisted that I join Mr. Sham Diwan. So I worked with him for a period of 4 years. And then I sort of branched out, becoming independent. But my experiences have been a long, arduous journey of constantly striving to improve your skill set. I think I'm slightly differentiated from my co-panelists because I'm an out-and-out litigator, and practicing in the courts on a daily basis. You are constantly meeting deadlines, and there's a lot of chaos in your life. So the best skills that it's good to start in college, like I did, because I was studying in England at that time. A good place to start would be to update yourself with the legal positions by reading judgments and making your core foundational, first principles very strong, be it in the constitutional law, contract law, or criminal law. These are the three core areas of law which I think everyone starts off with. And then in college, one must always try to do something which invigorates and they are passionate about. So I think they should do things which they like, and not get too burdened by what the future has for them. And they should do things which they're genuinely passionate and very, very driven about, so that ultimately sometime in their legal career they can reconnect with that passion and they can try to pursue that on a larger plan. My particular experiences in terms of cases, it will be very difficult to pinpoint because on a daily basis, we are constantly grappling with new legal issues. But what I learned from my own experiences is that one must be able to understand a particular topic, be able to eschew it, and then be able to apply it in a very short given standard of time, period of time. And that is because the situation in the legal profession, especially in litigation, gives you very little time to actually articulate your thoughts before the court. You may get less than 2 minutes before a Supreme Court, miscellaneous court to try to get a notice in a matter. And that is the practical view of, we all have to have an academic base and a very strong fundamental understanding of things. But in court, when we are practicing on a daily basis, what really demands is the practical situation, understanding what the judge wants, and being able to tell him in a succinct, sharp, and precise manner. Because nobody likes to waste time. I remember when I belong to a family of lawyers, and I'm a 4th generation lawyer, many people don't know. The times were very different when the earlier generations were practicing. The judges had a lot more time on their hands. Tomorrow and today, with the assistance of AI and with all these things happening now, rapid technological advancements, the judges also have become more impatient. So they don't want to spend possibly 1 hour understanding an issue. They will give you lesser and lesser time. So as a litigator, you must be able to be very precise and do all your homework in advance and not try to be, shaky and, not unprepared in court. The other thing that I've learned in my journey is that, you must maintain the highest standard of ethics. You must always learn from your seniors, your elders. You must be respectful to the bar. You must be, they say, you learn the most by standing on the shoulders of giants, for example. So that is how I have learned in my journey, by learning from my seniors. And constantly sitting in court and trying to emulate how to improve upon an argument. What more you could have done in a particular situation. So these are the sort of professional experiences, and now, I mean, after having worked for about 13 to 14 years, I feel a sense of, I won't say security, but I feel a sense of comfort in the profession. And I think that's come by constantly being self-critical and constantly trying to challenge your own status quo and try to move in a positive direction. And that happens with having overcritical parents as well. I think that helps you grow as a young professional. You know, having a critical family and a critical environment. So they say, a law can be inherited, but it's very difficult for you to inherit because you have to perform in court. If you don't perform the next day, you will never get another brief. That's how, because everyone is seeing you argue a matter. So that's the difference between being a litigator and being in a business, for instance. And as far as what my advice to the more younger aspirational students over here would be that in college, just chill. Don't worry about anything, just enjoy. Don't worry about the future, just really, really be passionate about things you enjoy and, for example, pick up a subject. Read as much as you can. Be a voracious reader. That is something there is no substitute for. Because in litigation and in law, your vocabulary is your biggest weapon. You must be able to understand the context and the text and the way in which words are used in very different situations. That would be my opening thoughts. Thank you.
Thank you so much, sir. Now that we are talking about litigation, sir, I would like you to answer another question of mine. Do you think that litigation is a field where it is a little difficult for the newcomer?
It's difficult not just for the newcomer, it's difficult for even the person who's a senior counsel of great vintage for about 30, because every day you are being challenged by somebody who is possibly 30 years younger than you. You would be in an argument with them and they would be very well prepared in their brief. Like Lamba was pointing out to me right now that people with bad memory may not be able to argue a matter, whereas somebody with a better memory will be able to outshine them. So litigation is constantly trying to apply certain facts to a given context and to be able to come out by an argument that sounds logic in the courtrooms. And the power of logic is something which is very, very strong if you really think about it, because when you're discussing and having a dialogue with the judge, then the only thing that really matters is logic. But for the newcomers, I think they should focus on their fundamentals, and I don't think it's difficult because with the assistance of AI, the field is becoming more and more level playing.
Thank you so much, sir. So the panel members, most of the panel members have practiced in the court of law. So I guess newcomers or people who are new to the field of law, many are not opting for litigation. Would you like to encourage students to opt for litigation? Because I think this is one of the most strongest pillars. No, but then litigation, as my students say, so the students who have passed out, they say going to the litigation, there is a lot of struggle. How would you like to encourage my students to opt for litigation?
You had only campus to court. Now you have campus to company as well. So there is not a law meant only litigation maybe 50 years ago. Today it is regulatory, today it is IPR, today it is competition law, today it is many things. So if you make a choice not to go to the court, it is not a very bad choice. But if you go to the court and learn the nuances, because that is where, so far as you are doing contracting law and things of that nature, you realize that how laws are interpreted, how contracts are interpreted, how procedures are important, what you want to take into consideration. You will be better equipped if you go to the court. But if you don't go to the court, now the options and the possibilities are immense. Many people, one example was Mr. Jyoti Sajan never went to the court, and he's one of the richest lawyers in the country. So therefore, you may be a tax lawyer, you may be a tax consultant, doing any advisory work. Going to the courts is very good Now thoughts can be affirmed, you can do it, you can argue online. So those opportunities were not there. But there is nothing wrong in not going to the court and still being a lawyer. There are many lawyers who do that. But if you do go to the law, if you go to the court, then you get a holistic view. You know how, in case of a dispute, how it is viewed, what is, you get a 360-degree view of a situation. And I think I'm a better lawyer having spent good time in court.
Thank you so much, sir, for motivating us. We have on the panel with us, who is every person's aspiration, Dr. Suni Augustine. Let's get motivated through his experiences.
Good afternoon, everybody. So, to start with, I was not keen to join the law. It was my parents who had insisted to go for law. And that is how I am here, by the God's grace. That is one part of it. Again, the second part is the hard work which you put in. Again, I was a science student, but was unable to take maths because in my school there was a cutoff of 65% and I got only 63. And I was unable to take maths at that point of time in 12th standard, 11th standard admission because that was the first batch of my school. So I had to opt for biology. So I took biology and computers as my optional or the subjects and then tried engineering or the medicine side but did not get through. So my parents told it's always better to go for some professional courses. So I ended up in the law college. And then when I did my law graduation, and as usual, merrymaking as usual went on, but I thought of doing company secretary there. I purchased the books, but again understood that that is again not my cup of tea, so I dropped that one also. Continued with the law. Then once I was in the final year, I thought of doing some post-graduation or masters in law. And it was at that point of time that in our adjacent university there was the intellectual property and human rights was there. So I opted for intellectual property laws. And parallelly I enrolled as an advocate, was practicing as well as doing my studies. And that was my turning point. In the sense, after doing my masters, I thought, why not try the government sector, that is the intellectual property office. Got the opportunity to work in the trademarks registry as an examiner, and there on my career path changed altogether. Came to Mumbai, that was in 2002. When I was with the trademarks registry, again opportunity is there for further studies, etc. So I thought, why not, because I was a bachelor, so why not utilize my spare time for further studies. And that is how I enrolled myself for my PhD at Mumbai University. And then, because you need to be a learner, because in the legal field, because for the legal side, you need to understand one thing is that there are two kinds of interpretation. And that is why the two lawyers argue for a particular case. So that is one thing which we need to bear in mind. So to be successful from your perspective, you need to do more research. And you need to give better arguments, better logic, which is convincible to the court. So that is one thing which we need to do. So just merely attending or just merely going with a haphazard knowledge or a partial knowledge will not suffice the purpose. And inquisitiveness for research is highly essential, and compilation of evidence. Because when you are at a corporate level or for a case, because majority of the cases at the courts are lost because of lack of evidence. So that is one thing which you need to have, that inquisitiveness for the research, because when you are in the corporate, etc., in what manner to gather the information, to gather the evidence to fight your case. Because the solicitors or the the external solicitors or the counsels will tell you bring evidence, you bring all the data. But in this context, what happens is that the concerned business departments or the business units are reluctant to provide the information. So there is the role of the in-house counsel coming into the play. With your cordial nature, with your supportive function with the business team, try to gather the maximum information from their side Also do a bit of research parallelly in the public domains wherever and possible to retrieve the information. And that will really help you in to be successful in the cases. So that is one thing which we need to bear in mind. Again, as budding lawyers or budding practitioners, because now the laws are getting changed. There is all possibility that the Advocates Act is going to also consider the legal practitioners. So in that context, say 5 years down the line, say 10 years down the line, you all, the working faculties themselves will be arguing your own cases. That is, if Goenka is having a case, your institution's case will be argued by the faculties themselves. You need not approach an external counsel for that. So that kind of arrangement might come in future. So we do not know. So in that context, everyone is going to be a litigate kind of person. So it will not be that even if you are not interested to go for a legal practitioner or a litigant lawyer, if you are getting some opportunity in some corporates, you will be mandated to argue your own case, being an in-house counsel, with the amendment of the legal practitioner or the Advocates Act coming into the picture. So that is also one thing which we need to understand at this stage, because in future it might not be that only the arguing lawyers or the practicing lawyers concept is going to come into the picture. It will be the legal practitioners. And legal practitioners is a wide terminology which is being brought under the new amendments which is being planned out, wherein the concerned person who is working in that corporate will be insisted, that is if the management, again it is the discretion of the management or the company, whether if you are willing you can argue the matter. So because now the bifurcation was that unless and until you make an application for personal argument, you are unable to argue the matters. But with this amendment, the advantage is that if you are confident enough to argue the matters, you can yourself argue. It will be a win-win situation for the corporates in such a way that the company is saving money on the approaching the external lawyers to that extent. And it will show also your capacity as a lawyer, in-house counsel also. So that is one. So from that is the aspect which we need to bear in mind, and the future innovative technologies which are coming into the picture. Again, the judges and all will not be wasting time on hearing the lengthy arguments of the lawyers. They will also be doing a research with AI etc. and coming on the bench. So you need to be very precise, as Mr. Singhvi had suggested. And another thing which we need to understand at this juncture is that you are having lots of opportunities for legal blogs and other legal aspects. So try to either subscribe to those which are free available, not only from the Indian perspective but also from the international perspective, and get maximum knowledge from that. Because for example, in the intellectual property there is this spicy IP blog. I don't know how many have subscribed to that. It is a fee, and it is again the initial budding legal practitioners who are venturing into the editing or the writing part of that. So lots of intellectual property related case laws and other things, the new regulations, everything are coming over there. Similarly, from the finance or the banking sector also, there are lots of blogs for the tax perspective. So what I would suggest is that along with your academics and other parts, you also subscribe and start reading all those, because there in these blogs the advantage is that you get everything in a gist or a very precise manner. You need not go in depth into that, but you will be able to understand that in a nutshell manner, and you will be able to gain knowledge of that. That is one thing. Again, another thing which I would also suggest is that whenever you go for some interviews or for campus placements etc., do a bit of research about that organization. In the sense, what are their legal background? In the sense, what are their legal cases? If you do a research in the Supreme Court or whichever websites, you will be able to know the relevant cases of those companies, and try to emphasize on that aspect in a very peripheral way. Because as a junior person, you are not expected to know much about that. But if you are, that will show your caliber as a research person, knowing more about that organization, which will assist you to get placements in that context. So these are some of the tips which I would suggest. So being a upcoming lawyers, don't expect that tomorrow you can bifurcate yourself as a corporate lawyer or as a litigant lawyer. So be ready for that and equip yourself. Thank you.
Thank you so much, sir. It was really insightful. As we all are aware that Ranjana ma'am has switched her career from science to law. Now, what fascinated you to turn your career from science to law? Were you afraid?
I was, to be very honest, I was not afraid. As I shared my journey from academic, from teacher to law, was this only. I accepted the challenge, how it came. And I listened to my seniors, I listened to myself, and with the dedication and that stuff that led me to be a lawyer today. So I can say that never afraid of what is there, accept the life the way it comes to you. So that was the inspiration where I moved from science to law. Because I'm a patent attorney, I'm still continuing practicing science as well as law. So that's the reason why I shared my journey, and Manish ji said that I am not that intelligent, but I can tell you that only hard work and sincerity lead me to achieve which I have never imagined. So this was the message to the audience that if you are regular, if you are sincere, if you are giving importance to the thoughts of your professors, seniors, self, then it is easy to navigate the challenges that we might be facing in this world. So, yeah.
Thank you so much, ma'am. So we have collected a few questions from the students. We would like to ask some questions. So in today's competitive market, legal departments need to offer operational clarity and build corporate resilience. I would like to question this specifically to Sanjayan sir and Sajan sir, that how do you suggest preparing these students for the evolving legal ecosystem?
Maybe in this challenging world, scenario, we need to balance between business and compliance. We need to grow with compliance. That is the challenge before us. And from business side, definitely there will be a push to the legal. Actually, sometimes they may treat the legal or compliance people as roadblockers. But in my view, we are not roadblockers. We are putting some dividers for safe journey and for avoiding accidents. That is the role of in-house lawyer in an institution. Apart from that, we need to protect the institution from the outside, maybe the claims or the cases, etc. We need to defend the cases also. We need to help, as Suni told, we need to prepare a proper brief for our counsel to submit before the court. From being an in-house lawyer, we should know what are all the intricacies of a particular matter we are addressing, and what would be the consequence also. The in-house lawyer we can compare with a law firm as a non-litigating law firm, because our role is to mitigate the risk. Maybe in the litigation side, they are defending or they are protecting. Maybe there's one issue is there, we are addressing that issue in the litigation side. But in the non-litigation side, or the in-house lawyer, apart from the defending the claims and the institutions, the other part, our duty is to anticipate the risk. We need to anticipate the risk and build a mitigation mechanism for safeguarding the interest of the institution. That is the role of an in-house lawyer in the institution. And in the banking sector, nowadays, maybe the banking sector means some institutions providing financial financial products or financial services. Now the banking sector is changing. It is somewhat like an IT industry providing financial services. Because the digital lending, we are going for digital lending. Now I think many of us, maybe especially the new generation, may not be knowing how to write a check, etc. They may be very much aware of their mobile banking, net banking, etc. Now net banking also gone. Now with mobile. That is in the digital area. Banks are providing digital services for digital enablers for doing financial services. that change also we need to accept, and we need to evolve ourselves also. We actually, in my bank or the Indian banking sector, earlier it was a mortgage lender or secured lender. That was the type of activity the banks were doing. Maybe the traditional lending for working capital or term lending, whatever maybe for lending for a particular thing. Now it has gone. Now majority of the banks are infrastructure projects, major works are there, like Adani and other banks are supporting. That is there. Apart from that, to the retail side, for digital lending and digital products, including credit cards and other small digital lending, that is the main profit generating area of most of the banks. That is why we are evolving. The guidelines are also evolving, and we should keep a balance between the evolving regulations as well as our ability to foster technological advancements. My answer to the students is that you should keep a balance between the business and the compliance, and you should take the right, form the right, the right rules and regulations you need to find out, and our legal role is to point out the risk in that. Business will take a call, because we need to highlight, if we are venturing into a particular thing, this will be the risk. Then how it is going to affect, we need to explain. Then business will take a call whether our risk appetite is capable of permitting that or not. That is one part. The second part, when we are venturing into a new product or new process, then we need to examine and we need to ensure that it is not in contrary to the existing laws or the laws of the land. That is the role of an in-house lawyer.
Thank you so much, sir. Sir, would you like to add?
Yeah. So I would like to supplement what Dr. Suni Augustine said and also what Sajan has said. See, the role of an in-house counsel. See, in-house counsel are generally considered to be decision makers, as I said earlier. So, if you ask who is an in-house counsel, a in-house counsel is actually a business person who happen to be a lawyer. That means your business knowledge in the industry which you are working should be at par with the business person with whom you are working. Then only the decision making will be correct. Because the legal knowledge you will be always applying to a context, specific context. If the context changes, then the decisions also may change. So this is one major aspect which you have to consider. Second thing, see, Sajan has already spoken a lot about the risk, because the kind of industry which he works. Of course, the industry which I work is also highly regulated. But I would like to share, see, a in-house counsel can also see one major aspect of the role of an in-house counsel is, of course, the legal risk management, which has, one is the compliance risk, the regulatory risk, and the contractual risk also. Okay, these are the broad categories. There are multiple other categories of risk which I am not venturing into that. So, but see, years before, I attended an interview in Etisalat, UAE, their headquarters. So, I'm just sharing my experience. I told, regarding the role, how, as an in-house counsel, how I am perceiving my role. So, I was focusing more on risk management. He asked, how can a in-house counsel be an enabler? So there are multiple ways, but one aspect which he has highlighted, which I would like to share, is that legal can understand the business requirement and proactively create templates, processes, even checklists, which can enable the business to roll out the products as and when they decide to roll out. So this is one aspect. And of course, in IP, I'm sure that, see, Ranjana ma'am can give more insight also. There are a lot of things, especially in IP, especially trademark, a in-house counsel can do many things which are proactive. Now, in today's scenario, we all are having 20 plus years of work experience, and the society has changed a lot the day we started, and if you look at as on date, the industry changed a lot. So change is happening and it is continuous. You have to, manage the change, go with the change. So you have to be very much updated regarding the regulatory environment. And few examples I can cite. See, it is very easy to study and understand a regulated industry today compared to an unregulated industry, because if you look at most all regulators are having website and they are very transparent in dealing with the matters which has a regulatory implication. For example, if you go to TRI website, if you read consultation papers, you will get an idea of where the industry is heading, especially the telecom, or I can say the ICT industry, information communication technology industry is heading. This is one aspect which you can consider if you are focusing on whether it is power sector. For example, power sector is going to be the sector for tomorrow. That is for sure. Because if you look at the last year's energy consumption, the highest peak energy consumption in India was 250 gigawatt, and it is expected to grow exponentially. So these are few aspects which you have to consider. And if you look at the today's scenario, see, in the morning we all were talking about artificial intelligence. Now lawyers can, in my view, use artificial intelligence as a knowledge assistant, because whether it is a legal counsel or a practicing counsel advising a legal counsel or a firm, he is either advising to take a decision or the in-house counsel himself is taking a decision. So the decision making cannot be replaced by a machine. So the sum and substance of what I am saying is that the technology has to be, you must learn how to use the technology to move forward and to the best of your advantage and to that of your organization as well. That's all.
Thank you so much, sir. So I have a question. What are some elements that the student should incorporate in themselves and of course their resume before entering the corporate world?
See, I don't know whether, resume is, generally how it happens, the recruitment process happens in corporate is that basis the requirement, HR will screen the CVs and give it to us. Now, for a fresher, there are not too many expectations. This is one aspect. Second aspect is that, see, you have to, the more important what is writing in the CV. So let me tell you, most of the candidates write a lot of things in the CV. And if you ask questions, simple questions based on what is written in the CV, they won't be able to answer. Not because they have not done it, lack of preparation for interview. Probably some might have not, just to get the attention, some might have added a little bit more also. So my advice will be honest and transparent. Okay. And for a fresher, I don't think anyone will have too many expectations. But if you have done a lot of courses, if you have done internship, see, basically if you ask someone, if you have gone for internship somewhere, if someone asks what is your learning experience, you should be able to tell. Otherwise, your internship certificate is of no use. That should be very clear. And what you can do, see, as I mentioned initially, you have to, stick to the fundamentals. Because as Mr. Avishkar Singhvi also mentioned that you must have a very good understanding on the contract law, constitutional law, criminal law. So the base should be strong. You can chill in college, there is no doubt. But the fundamental, the basic purpose of coming to university or college is to study. So you should not chill in such a way that you are forgetting the basic purpose. That is one aspect. Yeah. So you must have a clear understanding on the fundamentals. Why I am telling you, this is also based on experience only. Even in interviews, if you ask very basic questions to students, even about the simple things about indemnity, people don't understand. And from a practical scenario, I can say that the indemnification aspects may go even slightly beyond what is written in the contract law. So at least you must know what is law as it stands, and there are many areas to name and explain. It will take a lot of time, but sum and substance is that you have to be you should once you are out of college, you should have strong fundamentals, reasonable drafting skills. Okay, then I think you will be eligible for hiring by at least by most of the institutions wherever there is a vacancy and where you are applying. That's my view.
Suni sir, just to add to this point, what Sanjayan had told, because today, if you see, has anyone of you seen the arguments in YouTube? Any hands? Because when you get opportunity, what I would suggest is that instead of going and sitting in the court and listening to these arguments, just see those arguments. Because when you see that, it is equivalent to getting some, exposure or experience to the court itself. The thing is that you will come to know how a person is arguing the matter, how the judge is responding to it or reacting to certain things. So the advantage is that when you get some opportunity, because majority of you will be sitting late night, say 1 o'clock, 2 o'clock, just on the screen for various other things. So instead of that, if you are able to focus on some of these things, that will be really helpful to you in the long run. Because sitting in the court with all this, the environmental conditions, some of the courts are air conditioned and the high courts are all fine. But if you want to see the actual trial, you need to go to the district courts or the lower courts. But there, unfortunately, it might not be air conditioned. Some of the courts will be, but at times it will be very struggling time. So some of those will be available on the online. Try to go through those, understand it, and that will be really helpful. Because as Sanjayan told, you should never bluff with your CV. Just making it more presentable doesn't make sense. Because from a student, as I told you, do a bit of research on that particular entity or that organization which you are going for the interview, and be open to that. In the sense, if you are telling that I have done that, I have done this, with lots of things, because if they start probing in depth, it will be, you will not be able to explain it, or you will not be able to, withstand that cross-questioning part. So always be truthful to your CV and ensure that whatever is relevant, because instead of writing more on that, try to be presentable, try to open up yourself when you are having a face-to-face discussion. Because at times in certain cases it is again now everything is online, because in our case we do the first round of interactions over the video calls. So there also be open and be very straightforward, and that wherever you have knowledge, tell that. But again, as I told you, it is your opportunity to expand yourself, because we can limit ourselves to certain sectors or certain areas, because civil law is there, criminal law is there, different sectors are there. Intellectual property law is a different ball game altogether. So the thing is that we need to have some knowledge about everything as a student. Just I am focused only on a corporate law, or I am only focused on a civil law, because in a corporate law itself both a criminal part also will arise as well as a civil law will also arise. So stating to them that I am only focused on constitution law, I don't know anything about other sides, doesn't make sense. So you need to have a broader knowledge. That is why I think around 32 papers are there for your legal subjects. And be acquainted with the latest developments, in the sense whenever the new laws are changing, because now this IPC, CRPC have changed. So if someone asks you what you do or what is the major, what is your insight about that? So you should be able to give some light on that part. So it is not how much you know about the law, but what is your logic or your analysis about that, which is important for those organizations. So we focus on that part also.
Thank you so much, sir. But I would like Manish sir to add to it, please.
See, what I've seen is that there are a lot of C's which have come up. So what you need to be in the campus. You need to think about corporate, and you need to think about the courts. Study civil, as Avishkar has said, civil, contract, constitution, and whatever comes. But it is also important that context, content, and then confluence. That's what creates internet. So therefore, this word is what has created today. We had static websites. So context and content created a confluence which created all the magnificent 7 large trillion-dollar companies in US. And what ma'am has said, ma'am has also ignited a debate about knowledge and intelligence. Anyone knows the difference between the two? Any idea what's the difference between?
My name is Fanil Banerjee, and I think knowledge is facts or information, and intelligence is application of those facts, of how you can apply those facts to various situations.
Okay, you're almost there, but knowledge is always required, intelligence is innate. So therefore, if you collect a lot of knowledge, people will think you to be intelligent. So man is both, and apart from that, there is again information. There is information which is at the bottom. Then you have knowledge which you have to search. Above that, you have to apply is intelligence. And what makes very successful people is that they are wise. That is wisdom. And I think intelligence, we are talking about substitutes like artificial intelligence. Knowledge, if you go to the internet, you can get all the knowledge of the world, and if you go to the last 70 years of SCCs, you will know whatever the Supreme Court has done. But what you are required to do is that you need to have common sense, and you need to have the confluence of all three or all four. And that is where you have to work on your strengths and not on your weaknesses. And each one, if you are good at, as I said, that you need to know all. Yes, you need to be a jack of all and master of one. Choose your calling. See what you are good at. Eliminate all others. I was not good at maths. Couldn't do commerce. I was not good at science. Couldn't do science. I was reasonably good or okay at humanities. I took that. And I was left with no other option but to take law. But you reach where you have. So ultimately, you will have to look forward and look at your own strengths. Try to improve your weaknesses and concentrate on your strengths. Someday you will reach there. Thank you.
Thank you so much, sir. So this entire field of law is constantly evolving. All of you must be receiving a lot of fresh graduates in your firm, in your litigation. So what do you think, a fresh graduate, how exactly can they contribute in the firm's growth or in the growth of the organization they're working in? Sir?
So regarding young people joining firms, I think it's a recent phenomenon that a lot of them are opting for litigation. I want to correct you there. my learned friends on the panel want to dissuade you against litigation and are offering other lucrative opportunities. But I would say that all the youngsters are now finding litigation to be a preferred option. Like unless in the 70s and 80s it was a third option and it was a last resort, the vocation of last resort as they called it. But now I think people are finding it to be the profession of first choice. For the new entrants, with regard to how they can contribute is to be able to work hard and to be able to offer solutions, because I think every organization at the essence of things wants to find solutions. And when we talk about in-house lawyers, they are more solution oriented. When we talk about lawyers who are practicing litigation, they have to look at the correct position in law. And when you're an advocate, then you have to put the submissions in favor of your client to the court. There are differing roles, apart from the fact that in-house lawyers also must manage the expectations of their clients. And we have a duty to tell the client that this is not a realistic proposition in court and it will not fly. So with regard to young people, I think to have a holistic approach is very important. When you look at a case, there are many moving parts in a case. It's like an engine. But when we get a good clear picture of how the engine works, and each moving part in not in isolation but holistically, that is when you will be able to contribute to a firm, organization, be it a counsel's firm, etc., in a more meaningful manner, because then your solutions will be rooted in a practical scenario where your advice will be valued not just for your client, but also it may stand the test of arguments in court. I think that is one. The other thing that you could do is possibly try and do very good research. I think research is a dying art now because there is over-reliance on a lot of AI, etc. So people think that, oh, now AI can do it, but AI cannot do that kind of research, which requires nuancing of an argument. For instance, checking long documentations in the corporate scenario, which would lead to avoiding litigation. I did one case where one comma was missing in a document, and that was the whole subject matter of the dispute, was one comma. So I think, all these things, they do require human intervention. AI can only be the slave, it should not be the master. And AI can be used as an assistive technology, like Mr. Sanjayan said. But I think ultimately the human beings should be able to apply their minds to higher tasks and to more important utilities where they can contribute better. And as regards honing your skills, you need to do the basics right and learn all the fundamentals, and then you'll be able to add a lot of value to whichever organization you're in. Thank you.
Thank you so much, sir. So I followed Suni sir on LinkedIn. So sir posts a lot of vacancies in his organization. How do you deal with fresh graduates? What are the difficulties do you feel?
So as some of the panelists has already discussed, that is, what happens is that you will find lots of things on the CV, but when you have an interaction face to face, it seems just waste of time. So what we do at the first instance is that we do a preliminary screening about what is written on the CV, because it is not every sector will not be focusing on every aspect. So what is your intuition to that particular sector? Say for example, let us take an example of land acquisition. So in land acquisition, it is a very not that much interesting sector to do the title search, do the due diligence of the land part, and that too always in the vernacular language, etc. So there the technology comes into assistance, because now there are lots of softwares and other things which transliterates the vernacular language into the English language, so that it will be helpful and assisting you to do the understanding about that particular document. But again, as I told you, at times people will be, or the students will be very much curious and saying that this is very interesting. But at times what happens is that once they join the system, this seems to be a monotonous job, and they feel they want to be more into dynamic sectors, etc., etc. So what I would suggest is that wherever you are, that is whatever opportunity comes to you upfront, be in that organization for a minimum span of time, say 1.5 years at least. Be patient, because it is not that because I'll tell you again, one more thing is that for juniors it might be just MIS activity. I think you might be knowing what is MIS. Just compiling the data, or preparing for the presentations, etc. Or a kind of a paralegal work, assisting the HOD for his administrative activities, etc. So, I completed from this top tier institution, say NLS Bangalore or somewhere, and doing this kind of chingy job. It seems not that much digesting for me. So, at times what happens is that the corporates actually test that individual, because nowadays most of them do the psychometric testing and only then they recruit the individuals, even for a nominal placement for juniors also. So your character also plays a very important role. So you need to understand that part also. Your patience, because we need to be really patient, and when we compare with the kind of litigations or the practicing lawyers when we started in our say around 20-25 years down the line, it has completely changed drastically. So, but that doesn't mean that patience in that individual, that is presently the younger generations are not that much a patient type. So we need to develop that temperament, otherwise it will really lead to lots of chaos in the organization as such. So this is one aspect which we need to bear in mind.
Ranjana ma'am is running a firm. I would like you to add to this question, please.
I totally agree with you regarding the freshers that we hire in the organization. And there was a time 2-3 years back that we decided not to hire freshers. And the reason being that we were finding lack in patience. That was the main reason, where law firms like ours, we test patience in the first go. Second, as very rightly said, we should not overload our CV with too much of information which we have no clue about it. Trust me, with my experience, I can say when we speak to a person for 4-5 minutes, we know the depth. And we know what is written in the CV and what is the actuals. So, the patience is very important, honesty, transparency is very important. Again, I'll go one step back. It's good to have a diverse panelist and thoughts and discussions.
Absolutely.
And that's why, very humbly, I would like to disagree with you, Avishkar, on the aspect of chill. I'm a strong believer of the more you sweat in the field, the less you will bleed in the battle. So that's how, this is the opportunity, this is the organization giving me the platform to learn, absorb, and get knowledge, acquire, understand from each one of us. So again, if we really, end of the day, I want to have something on my CV. End of the day, I want to live a happy life. End of the day, I also want money in my account, right? So all that comes with what you are doing today. It's not in a day that you will get everything. So this is the opportunity where you can build up your CV, you can build up your confidence, you can build up your presentation skills, communication skills, writing skills, very important in legal thing. The drafting skills, very, very important. And as Avishkar said, that the communication skills, equally important. Because we have to be very crisp in front of court or in front of the examiner, controller. So we should work towards that, how I can make my CV strong. Again, the research part, I think Manish sir indicated about the research that we have to do more, so that I can incorporate the points that I have so research papers, and it can be of your choice. It can be diverse. If you have interest in the existing legal aspects, or it could be the emerging legal aspects, the emerging like intellectual property, space law, sports law. I think these are the emerging technologies where you can develop your interest. Certainly, we are here from the diverse group. Whichever fascinates you, whichever you have a passion about it, you can continue that. Yes, I think you want to.
I just wanted to clarify that, see, jokes apart, chilling means that you must do your basics right, you must do all your fundamentals, but don't get yourself too bogged down about what the future holds and think too far in the future. Because even, I think, even as litigators and even as lawyers, we don't tend to look that far, and we try to get the processes right. So once you have the process of working hard, being able to, understand the fundamentals, that is something which I'm sure that you're interested in, which is why you're in law school. But yes, on the overall sense, yeah, personality building, there are a lot of human qualities that go into litigation, which is also very important. Of how you speak, how you conduct yourself, how you talk to someone, how dignified you are in your approach. So these are the other things which to also work on. But don't try to don't try to be Einstein, because not everybody is as blessed intellectually, and not everyone has that IQ. So I think everyone has their own skill set, and everyone must realize that.
Yeah. So thank you for the clarification. I knew that you meant that. I was 100% sure that you meant that. But I have a teenager at home, and I can tell you from that experience where I again picked this up. When I say my daughter to study, my husband will exactly say what Avishkar said. Arey abhi isko chill karne do. And trust me, she will not listen to me. She is always with her dad on this aspect. So that's why, I again picked this up. I knew that it will be a sensitive act, the way the audience would like to learn. So, and this is what, again I have to fight back. कि वो वैसे ही नहीं पढ़ रही है. She's, she knows what she's doing, and she's thoughtful that I'm doing the right thing. What? She's going at own pace. But again, as I said, diverse mind. Women are from Venus and the men are from Mars. So certainly, the differences will be there. And as very rightly, you said that we have to balance strike a balance between the two aspects.
That's the mother speaking. So by chill, what he meant was that there is a book, what they don't teach you at Harvard, something like this. And those who have not read it, I would urge you to read it. I should have read it 25 years ago. Now I'm too old. So what is important is that what you're going to make over here, law is something you can learn from books as well, at the cost of your client also. And that is why it is called practice. Engineers work, doctors and lawyers practice. We learn at the expense of others. We get paid for it as well. But what is important is not only what is written in the letter of law, what is written in the book. By chilling, what my friend meant was that you must create bonds, friendship. You maybe a spouse may be sitting on your right or left. We don't know. You should not lose that kind of an opportunity. And all those people sitting over here, after 5 years you will be lawyers. After 30 years, some of you will be CEOs of the company. Some will be senior advocates. Somebody will be sitting on the bench. And if you have chilled together, you will be able to have more clients, more fun. So therefore, while you are making a living, life is happening.
In fact, it is a conflict between science and social science. Ranjana came from science background. Actually, my house also, my wife is from science background. She used to tell my children to study and all. Actually, chilling, I think what meant by Avishkar is that chilling is not the money making alone. Because as we are handling social science, we need to mingle each other, we need to see the society, we need to change the society, we should be adaptive to the society. Then only we need to address the problems of others. There, maybe in the other sciences it is different. Here, for institution or as a lawyer, as a litigating lawyer, we are addressing the problems of the society or a particular person coming for us. That's the difference, slight difference between science and social science. It is not chilling and
all, and hard work is no substitute, but life is also important. It keeps happening. While we are preparing for it, it is happening. So, if God is giving you an opportunity, make the most of it. Make this degree your tool, but not define your personality. You don't know what's for in life. Have fun.
I think what I can make out of this conversation is that we need to strike a balance between work and life. But I would like Sanjayan sir to give your input in work-life balance. How to maintain work-life balance?
Before that, let me just add to what the Sajan said. So, one aspect is that, see, if you look at our profession, legal profession, you will always, whether you are a practicing lawyer or a in-house counsel, it is quite probable that you will always have doubts. So, relationship building within this legal ecosystem is very important, be it with in-house counsels or with the practicing lawyers, with your CPAs, because that will be of immense help to you in the profession. Not because of not only in finding opportunities, but clearing your doubts and moving forward. So that is one aspect that you should keep in mind. Now, regarding work-life balance, see, I don't know whether, I am not a follower of work-life balance. I believe that, work will follow wherever you go. Because for a lawyer, complete detachment from work is practically not possible. The reason I will tell you, when you are working in a corporate or maybe as a practicing lawyer, the clients or your internal customers need you always. Okay, you will definitely, because problems will not wait. They will call you and ask you for solutions. You have to respond to it. So that is one aspect regarding, see, you have to live your life. There is no doubt about it. See, everyone has to find their balance. That may be, your work-life balance may not be at the option of your manager or the organization which you are working. You have to find it. Everyone is finding it. But trust me, if you are a lawyer or an in-house counsel or a practicing lawyer, work will follow you wherever you go.
Just want to add, Sanjay, I think the earlier days it may be more easy for marriage also. Maybe for the litigation side or the councils, it may be different because also they may be working. But the corporate or the other side, in the earlier days, they may get some even time and all. But now it is changing. In this, maybe in the meetings also, several meetings will be there, even in holidays, something will be there. But what we can say is that we can avoid that. But we should give some qualitative time to the family. Suppose if you are maybe 10 minutes or 15 minutes, we are interacting with the children and all, we take that time. Maybe from your side also, from your maybe people side also, when you are interacting, you also wish to interact with the parents also. Avoid this mobile phones and all. This is not for children also, from our side also. Maybe you are sitting in house also, there is a tendency to check mails or something also. When we are interacting with the family, we should avoid that. Whatever time we are getting, that spend qualitatively. That is my advice to and trying to practice also. I'm not fully successful in doing that. There may be tendency to do work in the even in family also, but try to give quality time to the family from parents side, from children's side also. That is also required.
Just one more perspective on this. I thought that since you're in college, you will be spending 5 years of your glorious young days and all your life you're going to be practicing as a lawyer, so it's going to be an exam every day. So in that context, it's better to, I mean, relax a little bit in the college. Not that you should completely chill, but it's otherwise, you know, every day we are doing an exam pretty much. So you must enjoy these early years at least as much as you can.
Just to add on to this work-life culture, companies insist for following this, balancing part, because now majority companies, when they do a psychoanalysis of their employees, either majority of them are becoming diabetic, BP, cholesterol or something. Majority of them, because of the stressful life is they are adhering to. So now the companies themselves have come out with a, if you see in the European culture, it has come a 4-day week, then 5-day week, etc., etc. And in certain organizations in India also, they follow what they do is that after say 6:30 or say after 6:30 say air conditions are off, after 8:30 lights are off. So the thing is that after 8:30 no one should sit in the organization or in the office, but the works will continue. So at least you can spend some productive time with your family. At least the presence of yours at home will make some difference. So in that way, because at times what happens is that the work will continue 24/7. So if you are going to sit like that, after say 10 years, 15 years, you might be hearing after the COVID, post-COVID scenario also, heart strokes, heart attacks, everything are coming. So it is always better to have a work-life culture and ensure that you are always healthy, for which presence of yours at the family or with the family is highly essential. So ensure that work-wise also, because the thing is that if you see the law firms and all, what they do is that in the evening say 6:30 or 7 o'clock, they go for a break, say 7 o'clock to say 10 o'clock. They do a complete complete leisure activities, and then after say 10 o'clock to say 12 o'clock, or depending on their work with the international clients or things like that, they do the work, etc. So we need to ensure that our health is not deteriorated in this entire professional culture or whatsoever. So that also we need to really bear in mind.
Lovely, different perspective to work-life balance. Well, Isha is a 4th-year student. She has a lovely question to ask all the panel members. Isha.
Actually, since all of you have experienced various challenges in your respective fields, what is something that you would advise the current student to incorporate in themselves to deal with such issues?
First thing is the temperament. You should build a mechanism, or you should imbibe the quality of the temperament. Actually, being a lawyer, maybe a litigating lawyer, so you will be able to. The other side counsel may be irritating us or helping us, or maybe we will lose our temper also. The same situation will happen in in-house office also. We need to address several issues. Suddenly some issues will come. You will be the minister of some issues also. Then being an in-house lawyer, the pressure will be more, because an external counsel can address, and he can win the case or lose the case. But an in-house lawyer, we have no opportunity to lose the case. We can't afford that also, because maybe in some stages we can advise. When we are proceeding with something, we can advise this is good, this is bad. That option is there. But once it is happened, our aim is to win our side. Either compensation, to avoid compensation, or getting compensation from the other side, or whatever may be the same. That pressure is there. But that also, our temperament should be there. And otherwise, if you are losing your temper, we can't study, we can't make proper presentations, or we can suppose in negotiations also. Some negotiations will happen. If you are losing your temper, you will spoil the entire situation. That's it. To my experience, to a lawyer, maybe the knowledge, everything is there. Apart from that, we need to gather the capability for keeping our temper.
Just to add on to this, one as we initially pointed out, patience is there, temperament is there. Another thing for the youngsters, what happens is that we might be coming into an organization or getting a placement on the expectation that acha bahut kaam karega, wo karega, ye karega. And as I told you, initially you will be given very minuscule or very minimal or a very nominal kind of work. So my advice is that you should not get frustrated. Utilize your opportunities and challenges in that organization for some productive aspects. Productive aspects means what is it? Improvise your knowledge. And if at all you are having more time, utilize it for some additional studies or something like that. So never get frustrated in any organization. And if possible, don't leave that organization within a span of 6 months. So whichever is the placement you are getting, be with them at least for minimum 1.5 years. I would suggest more period, but it all depends. Minimum 18 months you should be there, and whatever kind of work, in the sense it might be very minimal, very nominal or very hectic also. It all depends. It all depends on the organization and the structure. If at all there is a big in-house team, obviously it will be a monotonous kind of jobs which will come to you, because there will be a litigant team, there will be a contract team, there will be an advisory team. Over and above, there will be external solicitors or the practicing lawyers. So it will be a mixture of everything. So it all depends in kind of organization you are getting through it. So wherever you are, ensure that you do your best and give your best and be always a opportunistic. And you should not, अच्छा मुझे इतना ही मिला है, मुझे कुछ भी नहीं है, ये तो कुछ भी है, I expected something, मैं तो इससे भी अच्छा 5 साल कर रहे थे. So these kinds of confusions will arise and you will be confused, which should not happen. So that is one thing, as a upcoming budding legal professionals, you should bear in mind.
So I just add to that where I started, that when we decided not to hire the freshers, the reason was this only, because in KNS we believe in learning. It's a learning organization, and we spend good dedicated time. We invest in our people. So whenever we were hiring freshers, we were investing a lot of time, energy and money also, because in 1-2 years they're not. They will learn in 1-2 years, and then only they are in a position to deliver. And because we work for clients, and we also can't afford to lose the clients. So in any case, if the dedication is not there, then we will suffer in giving the good quality work to the clients. So to the freshers, to the learners, the message is, you are the brand ambassadors of your freshers, your juniors. So whenever you join an organization, give an example that freshers are the first choice to be hired in any of the organization, whether it is court, it is school, it is academic or any law firm organization. So that patience is required. And again, I'll just share one example. When I started my career as a scientist, I started with cleaning glasswares. Cleaning glasswares. I did that for 1 month. Only cleaning glasswares, because if my glasswares are not clean, trust me, reaction will not happen. No matter how good ingredients I am mixing, but it will not happen. Same when I started my career as a patent attorney, I drafted forms. There are multiple forms which are required to file an application, 1, 2, 3, 26, power of authorization and all. After with 6-7 years of work experience, I was preparing forms when I joined KNS. And that forms explained me that what the process is all about from filing to grant. So that's what I said, that patience is very important. Otherwise, and this job is done by secretary in our office. It's a paralegal job. It's not scientist, it's not patent agent or any expertise is required. But the patience hold me. Means that's what, the patience or the hunger to learn more. So be brand ambassadors of your juniors and stay in an organization which has given you an opportunity to start your career, which has given you an opportunity to learn and grow.
So just to supplement what Sajan and Ranjana has said, both of them articulated the requirement of patience. I fully agree. At the same time, I will also tell you that you must practice detachment, because the reason is that, of course, a practicing lawyer to a great extent, as per law, of course, they are required to be detached. Otherwise, that is why an advocate is not supposed to accept a brief where he has some interest. So, in-house counsel, as we discussed earlier, he is actually standing on the shoes of a client. Now, during negotiations also, if you are, see, lot of bulldozing or lot of high-handedness you may experience during a negotiation, but if you practice detachment, that will help you from being unaffected by these kind of things during a negotiation process or during your work environment in an in-house department. The second aspect, see, of course, pitfalls are not uncommon. When you are when you start your career or when you progress in your career, a slip can happen from anyone. So, two aspects which one of my earlier firm taught me is that, see, in consultancy, they have a practice that whatever goes to the client, at least 4 eyes should see that. This is one way of looking at it. Second is that, see, when I joined Reliance, after some time my boss was recommending a book, you might have heard about that, a book written by Dr. Atul Gawande, Checklist Manifesto. So, even to some extent, the risk or the chances of errors can be mitigated by using a checklist. But checklist is not everything, which I agree. And the third aspect, see, most of the time, probably, see, you have to be updated because most of the time, if you are not updated, you are likely to miss certain things which are very critical. And one more thing regarding, see, probably, see, Ranjana ma'am has mentioned that, why, the firms are reluctant. That is a practice in corporate also. In corporate also, they are reluctant to take freshers. See, for one reason, just to supplement, is that, see, it is very difficult for an in-house lawyer or in-house legal department to hire someone, train and make him utilize for the work. Now, in this context, I would also like to, but you should not be disappointed by this. For one reason, I would like to say, now the legal landscape is changing in India. You might have seen that Telecommunication Act 2023 was notified last year. Okay, the commencement was notified. And the Indian Telegraph Right-of-Way Rules 2025, which is very critical for telecos for the rollout of infrastructure, got notified as on 1st January 2025. Now, when a new law is notified, see, the level playing field of a new entrant and an experienced professional is almost the same. See, little bit of difference you may find because of the experience, but when a new law is passed, for example, DPDP Act is yet to be, the commencement is yet to be notified. These are opportunities for youngsters. I would also like to quote what my IDT head, indirect taxation head in Reliance, told me when GST law was implemented in 2017. See, he has vast experience in service tax. Now that has practically gone. He said, look, GST law is now in force. The level playing field for me and a fronter is almost the same. It's an opportunity. So create experience. Now even, see, if you have reasonable drafting skills, you are likely to be hired by, even by law firms or even by in-house departments in corporate. So develop certain skills that could help you a lot, because if you look at what is experience, experience is an ability to respond to a particular situation. See, I have 20 plus years of experience. Sajan has 20 plus years of experience. The work which Sajan handles, I can't handle because I don't have experience. But if you work in a banking sector for 2-3 years, even if you will be more equipped to handle that situations than in a experienced lawyer who has expertise in other domains. The profession is so vast. So you have a lot of options to choose. That's all.
I totally agree with you, and that's what I said 2-3 years back. We decided not to hire, but then leadership soon realized that with the freshers we can't grow. And we hired 27 freshers last year. In fact, in my team, I hired one chemical engineer, and the reason for the hiring was that he had add-on experience of machine learning and AI. And I am zero in that, and he taught me a lot about machine learning and AI. So this is how, without freshers, without young blood, young generation, the latest knowledge, the existing organizations can also not pick up that fast. So don't get demotivated with that. We stop, but at the same time, lesson learned, and we are very much hiring the new freshers. But patience is really required, and gratitude is expected in turn, which when we invest time in the freshers. Yeah.
See, I cannot burden you with a lot of advice. You have already got good advice. And lawyers should not give free advice. So, mother's milk and honey is always good. So I can give you a lot of such statements. Just try and be better version of yourselves. Learn how to add value. And you must also justify your position. Why should somebody take you? Why should somebody hire you? Why should you get an opportunity? Once you keep answering these questions, things will get sorted out. Unfortunately, careers and life cannot be lived vicariously. You will deal with your own set of problems. You will deal with your set of issues. The times will be different. They will ask you different kind of questions, and you have to find answers to your own problems. That is something law cannot be taught, it can be learned. And practice is a journey, or life is a journey which is so generous to you, and you will have to do. You can get nuggets of wisdom everywhere. Life is a buffet. Pick the best for yourself. Make the best utilization of your degree. Don't be a slave of it. If you find that you can do MBA thereafter, do that. If you can become a journalist, do that. If you find that using this degree you can become a businessman, do that. And be a better version of yourselves. Life will unfold and give you opportunities. That's what it is.
Thank you. Thank you, everyone. I would like to open the floor for all the students to ask any question. Anybody? Shikuti? Aditya? Can you please pass the mic to Shikuti?
Greetings to one and all present here. My name is Shrikuti and I'm a third year BCom LLB student. And my question to you is that what practical advocacy skills were most challenging for you to develop when transitioning from law school to professional practice, and how did you overcome this challenge? No, I want each of you to answer the questions. I'm a little troublesome, I'm sorry.
Okay, so just to start with on this point. So when you are a practicing lawyer or when you enroll yourself, you have the lot of enthusiasm and urge to know about lots of things. So as a upcoming lawyers, what I would suggest is that everyone should enroll yourself as an advocate at the first instance. This is my, even if you are going for a corporate side, first enroll yourself. And then what I would suggest is that go and attend the courts. Because attending the courts will really equip yourself to understand and evaluate a particular situation, in what manner you need to argue a case, etc. Because studying theory and practice is entirely different. Again, the procedural aspects also is very much critical and important, because if you see, if you file a say 100-page document in the court, and if there are some defects in it, unless and until the defects are cured, it will not come before argument. So, being a lawyer, it is not that argument part is what you need to know. You also need to know the procedural aspects. So, when you go for a big law firms, etc., there will be the bench, the law clerks or the clerks who will be assisting for filing. If you get an opportunity in those law firms, be or accompany them to the behind the scene, that is behind visit the administrative section along with them when they do the filing, so that you understand that part. Again, another opportunity which will arise for you if you are a bit more interesting to do an argument is that there is this legal aid cell. Be a member of the legal aid cell, in the sense free legal aid cell, because in all the courts now there is this free legal aid cell. Enroll yourself in that free legal aid cell, and when you get an opportunity to give some legal assistance to a person in the prison, or who is not having that much amount to spend, etc., give some free advice. That kind of knowledge sharing from your side will really assist you. So these kinds of small things as a initial stage, because the initial stage will be a real struggle. So you should not lose your, as we had suggested, that is, we should not lose out on, this is not my cup of tea, because most of the upcoming legal professionals will feel that unless there is a financial support from the family or someone, you will feel that yes, so minimum 5 साल के बाद ही कुछ पैसा हाथ में आएगा. But now the situations have changed. This was the good old days when we used to do the practice. But now the things have changed. So I think in the initial placements itself, you are getting better perks, etc. But you should be hardworking and not just sitting idle. This is the simple advice.
I think your question was what were the skills you found most challenging to develop. So just regarding that, I think one thing is mental toughness is very, very important. Tenacity, your grit, your determination. That those are the things that ultimately the guys who come through as the succeeding ones are the ones who are most mentally tough. And this is what I found in my personal journey, to be able to detach myself from what happened in the courtroom on a particular day, to come out after that and not be emotionally attached and not let it mentally affect you, the outcome affect you. It's very, very important, because every day you don't come out on the winning side. In fact, even Rahul Dravid, who I used to really idealize, he once said that even in my career of having achieved the pinnacle of success, I have failed 90% of times. So you have to realize about how to deal with failure and be mentally tough and learn from every failure. That's very, very important. The other things I'm sure your university professors and your seniors will teach you.
Any other questions from any students?
A very good afternoon to all esteemed panelists. My name is Anurag Singh. I'm currently in the 5th year of BLLB Honours course. Actually, I have 3 questions. My first question is to Sanjayan sir. Very recently, Reliance Jio has entered into the cryptocurrency space with the introduction of GeoCoin, a blockchain-based reward token. integrated within its proprietary web browser Geosphere, where users can accumulate geocoins by engaging in various activities on Geosphere. So coming onto the question, given the resistance among the lawmakers, RBI and the stakeholders with respect to the cryptocurrency, what's the future of the geocoin and what are its associated risks?
This is a very company specific question. I can't answer this.
No worries, sir. I have next question.
Yeah.
So, in the legal profession, both in-house legal team and law firms play a crucial roles, but their work dynamics, challenges, and career path differ significantly. So, sir, given your experience, how do in-house legal teams differ from law firms in terms of work culture, challenges, and career growth opportunities?
See, work culture depends upon organization. Okay. Probably even some corporate you have to spend a lot of hours. Depending on the situation, as I mentioned earlier, it all depends upon whether you are an in-house counsel or in a law firm. You have to meet the requirements of your either the internal clients or your external clients. In case of law firms, so that is one aspect. Now the difference. If you ask me, the difference is very simple. One, in-house counsel is a decision maker, external law firm is an advisor. So, being an in-house counsel, you should have some kind of reasonable decision making capabilities. You have to cultivate or you have to develop that. You are taking a call based on the advice, which is given by probably by the external counsel or basically what you are discussing internally with the business teams. So this is one crucial aspect. Now the second aspect is that probably most of the law firms I interacted, my experience is that industry knowledge, at a senior level, partner level, it is different. They are, comparably, equally knowledgeable most of the time. Like a in-house counsel, but most of the juniors, industry experience or industry knowledge is very, very poor. So your application of your legal knowledge will go wrong if you don't have industry knowledge. So if you are practicing, focusing on any particular area, you must develop knowledge with respect to that industry. And to add one more aspect, likes and dislikes, including professional likes and dislikes, may change over a period of time. You can't predict, what I will be or you will be after 10 years down the line, precisely. It all depends upon various factors, which area we may be practicing. So, adaptability is another quality which you have to develop. That's all from my end.
I would like to request some input from Sajan, sir.
In-house lawyer and external counsel, you may be mentioning the law firm means the practicing. The law firm means there are the litigating law firms and the advocates are there, and advising law firms are there, giving opinions also there. The advising law firms somewhat to a certain extent we can equate with the in-house lawyers, but the difference is that the in-house lawyer is dealing, viewing everything to the particular institution itself. But the law firm should have a broader outlook. Maybe they may be handling, suppose say in banking industry, today they may be advising to Federal Bank, next day they may be advising to HDFC Bank. Their products will be different. Maybe in the similar category we are placing it, but the product, process, etc. will be different. That is why a good corporate law firm dealing a particular subject, maybe a particular area, is catering many institutions. That is the opportunity to get acquainted with the regulations, the statutes, and the various aspects of operations is different. But when we are limiting to a particular institution as an in-house lawyer, we are also dealing the entire thing, but our entire focus will be on the particular product or particular process we are following, and we are defending that also. That will be the one change, maybe the one distinguishing point between a corporate law on a particular topic and other thing. And here actually are coming regarding the corporate matter. The people are maybe the students for joining corporate. The panel, that may be the reason for Jairam and Nikina choosing the panel for this. Otherwise, Singhvi is equal to balance hours. He'll be able to balance hours. Maybe this much 5 people are required to balance the litigating lawyer. That is one side also. Minority in number. And one more thing, and the opportunity for practicing lawyers are there. You concentrate on that also. Do not limit yourself into corporate side, and maybe the opportunity to get initial starting. That may be tempting you for taking the corporate field. Maybe it's a pyramid. In both sides, the litigation side or corporate side, it is a pyramid. And those who attain the top position, they will be maybe from the from the rewarding side, some it will be good, but it cannot be equated with the practicing lawyer in the top position. That is different. But the opportunities are same. Maybe the initial days you may feel comfortable in corporate side, but as you are growing, it will be interesting and you will be more rewarded in the litigation side also. You should be mindful of that. Don't jump into corporate side. We are not advocating for corporate side. Being a law student, you should aspire for both these things.
Thank you so much, Sanjayan sir and Sajan sir, for your insights. I have one last question with Avishkar sir. Sir, as you were discussing about AI, sir, with the increasing use of AI in contract drafting, due diligence and compliance, how should young professionals prepare for a tech-driven legal landscape and how effective they are in reducing legal risk? Thank you so much.
That's a very pertinent question, and I was recently part of a panel discussion and a debate regarding the Jindal Global University, which I must commend to Dr. Jayaram here, that they have started a new course in AI. And there's a new course which is starting this year, which is pioneered by Professor Chancellor Rajkumar, and it's in AI. So I think regarding AI, you must be extremely circumspect by using AI blindly. First thing is AI is like a child, it needs to be trained according to what you're feeling and you will get, unfiltered information. So my experiences with AI have been that you must do your own research, and you can use AI after it is very well, it's like a well-trained, assistant for you. With regard to using, for legal research, I think in the future with better tools coming in, it will really enhance the kind of research that we use and the manner in which we, argue our cases in court. So that will be another very big benefit. And for younger people to use AI, I think we must know how to use the system very well, but you must not be overly dependent on it. You must be able to go to the books also when required. And as far as using it in courts, that's a new debate altogether, because AI is now soon to be going to be regulated very strongly also. And in fact, the last discussion had the two eminent Supreme Court judges. They had the Solicitor General, my father happened to speak on that occasion, and they were discussing how to involve AI in the legal sphere. And currently, the Chief Justice of India is also using AI to fast track disposal of cases. So at many levels it's being used, and the manner and then the way in which you use it as a litigator, as an administrator, as an in-house counsel, or be it as a patents advocate who is filing patents, there are many ways in which you can use AI. So I think, yeah, we must use it, but we must use it with a great degree of caution.
Thank you so much, sir. We will. One last question from Dean, sir.
Ask about a totally different dynamics of our profession, which our students also will be interested. Except Avishkar and to a certain extent Ranjana. In-house counsels are more worried about risk, mitigation, management and avoidance, and to a certain extent compliance as well. So what about conflict management? So most of the time now Mediation Act is a reality. Arbitration also is picking up. What is the scope of arbitration and mediation specifically in corporate sector and for students as a preferred choice of practice? Again, we have actually started off with an arbitration center which is actually going to be functional here. So what is the scope of that? Like
Okay,
as a SPD dispute resolution mechanism?
So it's a mixed bag, but I'll just throw you some statistics. Delhi High Court has around about 100, 120 new commercial cases every month. Disposal is between 60 to 80, so there are around about 1,500 cases which come. There are 3,600 commercial cases while we speak which are pending, and this data, don't hold me, Google it and find it out and say it was 5 less or 5 more. So I'm just giving you the averages, and you can go to the Delhi High Court and look at it. And the number of arbitration applications which have been filed are over 3,000 for the purposes of appointment of an arbitrator. There is also in MSME Act, if you look at it, there is a statutory arbitration, and not very far from here, the arbitration center is there. So our opportunity and our situation is such that the courts are not able to handle. I am not saying that whether it is a good or bad, but this is one experiment which the government is looking how to reduce the docket size. So this is certainly an alternative dispute resolution and things of that nature is the government is examining, and this would explode to be a big thing insofar as MSME part is concerned. Apart from them, there are certain acts which provide for statutory arbitrations. The Electricity Act provides for in some certain situations. There are other acts which provide for statutory, like SEZ Act provides for a statutory arbitration. So it is, you must look at it as a litigation or non-litigation or disputes practice. And this should be one of the things. You cannot put all your eggs into one basket. Students may have come from other regions and things of that nature. Arbitration is good for Delhi, Bombay, Calcutta, Madras, old schools, say the old names, or the larger cities. But once you go to the hinterlands and things of that nature, I am not sure how large the scope is. But there is a ODR is again, ODR is only a mechanism, so ultimately ODR is just not, the government is not happening till tomorrow, not being able to see, but the new arbitration with respect to MSME thing is concerned, I think that will be a big opportunity. In IPR, WIPO does a lot of disputes on ODR. Banking sector of the ombudsman side, it does, but on the other side, there are arbitration clauses, but then you'll find DRT and IBC taking it over, because wherever there are secured, but there could be possibility of using it for credit card payments and loans and small things of that nature. It has not been tried seriously enough. There is an opportunity. I was also speaking with the government. The government is one step forward, one step backward so far as conciliation is concerned. There are already talks that pre-litigation mediation, they think there's going to be a white paper on it, whether it is good or it's a waste of time, or what is. So we have done that, but we have done that in a major, but once the dispute arises, then all this becomes academic. Then all this, there is no mediation which happens. It only happens once you have burnt your fingers, you have wasted your time in the courts, and angers come down. Then all this becomes sensible. But otherwise, like IPR, you cannot in trademarks, you can't have, where there are public rights, you can't have an arbitration. So arbitration has its limitations. So the signals from the government and from the industry and from the experience are very mixed. So it is a great opportunity, but we don't know eventually how successful it would be. But certainly there are many experiments which are happening. And I think the biggest one is your MSME. statutory arbitration is something which is, I hope they bring this arbitration and open to many insofar as consumer disputes are concerned. The value is low, the cases are too many, and if they do that, I think it will open a floodgate of opportunity. Yeah, infrastructure insofar as the private size is concerned, insofar as international commercial arbitration is concerned, you don't have an option. Because then when two sovereign countries are involved, you have the New York Convention and things of that nature, what it provides. But insofar as infrastructure government experience is concerned, it has not been very good because of a circular which you would have seen with respect to the arbitration. The government has given an advice to its department saying that any matter which is above 10 lakh rupees or something of that nature, please don't go for an arbitration, please put reasons in writing. It seems that we are not sure in which direction which we are going, but it is a new area, it is an area which has had its ups and downs. In US also, in some states it was bad, then it came back. AAA arbitration is all very good. So, land acquisition matters, you have an arbitration, almost an award. So I really don't know, but this is an opportunity one must have an eye on, and as a student, it is very important. But if you are basing your career in international thing and the manner in which Singapore, Dubai, London have come up, it is a good option, and it is one of the most lucrative, and unlike what it has been touted as, it is not cheap. It's very expensive and a gold mine for lawyers. Did I answer it?
From banking industry, I have a different perspective. Actually, we also prefer arbitration, but there are some limitations to arbitration also to banking industry. The issue is that if the particular debt, there are two parts. Regarding our contracts, our relationship with partners or service providers, we do arbitration. That opportunity is there, but that is limited in number in our folder. But generally, for lending activity, for our customers or borrowers, there are some limitations. One is if what is the arbitral claim? The claim amount is more than 20 lakh, we are not permitted for arbitration. We need to approach the RT. That pecuniary limit is there. Second, if it is more secured by mortgage also, it is not permitted. That is why in banking industry, generally the arbitration is happening for the lower bucket, for the small amount, the credit cards or unsecured or personal loans, arbitration is going on. But actually, there was no fairness. Earlier, there was no fairness in that. Actually, unilaterally, banks are appointing one arbitrator. Maybe the customer sitting in Kochi has to appear before an arbitration, they think it is not happening. That is itself one-sided. Now, because of the intervention of the Supreme Court, maybe the recent judgments, there is some fairness. In Kerala High Court went ahead to that also, and making that the appointment of arbitrators should be post-dispute. That is a position in Kerala High Court. Otherwise, in Supreme Court, it should be arbitrators should be appointed by both the parties, maybe agreed by both the parties. That fairness is there, but then also because of the pecuniary and other limitations, we are not able to do arbitration in a bigger way. But hope maybe in the coming days it will evolve, and we also do prefer arbitration. There is some limitation in the banking sector.
So far as we are concerned, see, of course, most of the corporate prefer arbitration because of the confidential nature of the proceeding. Second aspect, I personally believe online arbitration is one of the good options, and we have in certain contracts we have incorporated a provision for online arbitration by designating an institution. So I think most of the corporate are adopting it, or there is a future for that. But there are certain issues as well. For example, if the vendor is an MSME, it may not work. Okay, because it will go to facilitation center as if they raise the dispute. Okay, so and if it is related to payment or a post supply or post provision of services, and with the strategic and large customers, it may not work. Okay, of course the stakes also will be high. The typical vendors who are having low stake in terms of the amount involved, they generally accept or they are not bothered. Rather, I would like to say. Now, Manish ji said that this may be academic, but see, few cases it was tested, and it was quite okay. It was not so bad. So now I agree with Manish ji in the sense that you can't predict that whether even after putting a ODR clause in a contract, the vendor can still challenge it. Okay, for multiple reasons, those possibilities are there, but it is a very good option. There is no doubt about it. Regarding mediation, of course, mediation is one of the best options, because no corporate or no in-house wants to go to court at the first instance. But many a times, see, the vendors or of course the customers will go to consumer forum only. So the vendors may not be willing to come for a mediation. That is one practical issue which we are facing. They may come and discuss internally, but they may be through an institution. In all cases, they are not willing. But of course, online dispute resolution, I believe, will have a good future. And because it is very, very cost effective. If you look at, if you put a clause for a mutually agreed arbitration in a contract, most of the time, practically you are aware that, mutual agreement will never happen. It will end up in court for appointing an arbitrator. So the time required, okay, and the cost involved, please factor all these things. On a fraction of this cost, online arbitration is possible. And it will be a great opportunity for students as well. Means once they become lawyers. Yeah.
Without being a lawyer. You can be appointed as an arbitrator even before you complete your law. I think I personally had mooted an idea that there is collectively so much of intellectual capital which is there insofar as teachers, lecturers, professors are concerned, students are there, at least very low value insofar as the consumer forums have completely failed. They can go and appeal, but this part of the pain should be taken over. You have institutions, you have integrity, you have continuity, you can be monitored. So I think this part must go, traffic challenge and everything must go to AI to decide, and anybody can go to appeal. So we are heading towards an exciting time. The academia in India and the government and the corporates have not been able to utilize and create that synergy, which is possible if you bring in more ease of business and ease of living. But I don't know when it will happen. That's fine.
On arbitration, the legal standpoint, I mean, there are many different kinds of arbitration. It's almost like an amorphous space now. Whether you talk about statutory arbitration, like under the MSME Act, I've had privilege to do a lot of those references which happen under Section 18. There are institutional arbitration, there are private arbitration, there are government arbitration. So, first point that you must know is once you have an arbitration clause, that you are stuck with arbitration, because 99% of the courts will relegate you to arbitration. And you are not just stuck with arbitration, and me and Mr. Lamba were discussing in the car, you are also stuck with the arbitrator, which may be a bigger problem at some points. It may be in your favor, whichever side of the aisle you are on. The other issue is the scope of interference. In the arbitration award, as we see from the recent judgments of the Supreme Court, etc., the scope of interference is extremely narrow. So, for instance, if an arbitration award is perverse or unreasoned or against public policy, then there is almost virtually a very small, narrow scope of interference that the courts are permitted to do. while this is in the interest of speedy disposal, the objective of Section 89, which is alternate dispute resolution in CPC, was originally there was a report of the Law Commission to declog the courts. And in the endeavor to declog the courts and provide a speedy disposal, you are really compromising on the quality in many instances, in my view. I'm not anti-arbitration, I'm just saying that arbitration must have essential safeguards. And the last thing is, how do you regulate the arbitrators and you know what happens during the arbitration proceeding? Because I've seen and I've been witness to a lot of, you know, I don't want to mention unpleasant exchanges during arbitration that I've been part of. So there are issues with arbitration, but the courts also must not miss the wood for the trees. Just to ensure that they will, you know, have a speedy disposal, they should not compromise on the quality. And that is the judgment that is currently pending before the larger bench today in the Hakim case, which is the modification. To what extent can courts modify arbitral awards? That judgment will, I mean, it's a very difficult one to reconcile, and I think ultimately, whichever way the courts go, they will be criticized. But I think the courts will lean, this is my premonition, I think the courts will lean in favor of modification because that's in the interest of the overall system on several grounds. So let's see what happens in the evolving nature of things as regards to arbitration. In India, I would say it currently already is a main street alternative distribute.
Ways in which to deal with that mystery. Arbitration will be a poor cousin and a poor substitute for a poor man.
I mean, recently we saw a very large arbitration award being set aside by a 37 court, Justice Rekha Palli. They set aside, in fact, incidentally, that the Reliance award, treating it as a domestic arbitration. So I mean, you know, the courts also may err on the side of over interference. So it really depends on what side of the judge, what side of the spectrum you're on. But the other problem is that, you know, the 34 that Sir is mentioning also lie before district courts in many instances, and very difficult to train the district judge on how to appreciate an arbitral award. And in a lot of parts, not that they're not trained, but the constant evolution of the arbitral law, it's very difficult to, you know, constantly tell them that this is your jurisdiction, this is how much, because when you're a civil judge, you have the plenary jurisdiction, you can do whatever you want, and pretty much under the inherent powers. But in arbitral jurisdiction is very narrow and specific. So to be able to make sure that that training goes across is also another aspect of arbitration.
I wanted to touch the mediation. In banking, the mediation plays a major role. The mediators, we are resorting to mediators, and for what else is it? We are litigating on one side, but we are not recovering the money. The bad debt we are not recovering mainly through litigations. We are through mediations only. And under the new the Commercial Suits Act also, mediation is mandatory. And maybe the students or you can develop your skills as a mediator, and that is enormous role since because there is no legal barriers are there. You can mediate with the clients or with the customers. We are resorting, we are engaging personal mediators also for discussions.
Thank you everyone. I would like Harshita to please carry on with the event.
Before we conclude, I would like to extend my heartfelt gratitude to our moderators and our panelists for their valuable insights and engaging discussions. Thank you for sharing your time and expertise with us today. It is an absolute honor to be here today on this special occasion, International Women's Day, as we come together to inaugurate two significant initiatives at GD Goenka University, the Center for Women and Child Rights and the Center for Corporate Law Policy Research and Governance. Alongside social justice, legal education must evolve with the changing corporate landscape. The Center for Corporate Law Policy Research and Governance aims to bridge the gap between legal theory and corporate practice, fostering research on corporate governance, policy reforms, and business ethics. Now, I invite all the panelists to inaugurate the Center for Corporate Law, Policy Research, and Governance, along with the Brilliance.
Shivangi?
Center for Women in Child Rights, CWCR, on a day dedicated to celebrating the strength, resilience, and achievements of women, it is only fitting that we take this step toward ensuring their rights, protection, and empowerment. The Center for Women in Child Rights will serve as a hub for legal research, advocacy, and policy initiatives, working towards the gender justice, child protection, and legal awareness. To inaugurate the centers, I now invite Ms. Ranjana Singh ma'am along with Dean Sir and Ms. Reena Parveen to formally unveil the Center for Women and Child Rights. With these two centers, GD Goenka University takes a significant step toward legal excellence, advocacy, and reform. Thank you so much, everyone. Now, I would like to invite Dr. Ankita, Associate Professor, School of Law, GD Goenka University, to deliver the vote of thanks.
Good afternoon, everyone. As we draw curtains to today's event, it is my great honor and privilege to extend a heartfelt gratitude at the conclusion of this enlightening Induslex Confluence. On behalf of the School of Law, GD Goenka University, I would like to express our deepest gratitude to our esteemed panelists, Ms. Ranjana Singh, Mr. Manish Lamba, Mr. Sajan Mathew, Mr. Sanjayan K, Dr. Suni Augustine, and Mr. Avishkar Singhvi for taking time from their demanding schedules to share their life experiences and legal expertise with all of us today. Your insights into litigation, corporate world, dispute resolution, regulatory compliance, and industry best practices have been truly invaluable. We are humbled and enlightened by your engaging discussions, thought-provoking perspectives, and practical advice, which have provided our students with the real-world understanding of the legal landscape. To our wonderful students today, your participation with zeal and curiosity and your thoughtful questions have made this interaction even more meaningful and engagement that makes such initiatives successful and impactful. My sincere gratitude to VC Ma'am Dr. Kim Menzies, Registrar Ma'am Dr. Anuradha Tiwari, and our Dean School of Law Dr. Jairam Sir for their continuous support throughout the planning and execution of this event. Without them, the event of this scale wouldn't be possible. I would fail my task today if I do not thank the faculty coordinators of the event, Ms. Hina Parveen, Ms. Sania Kapoor Wadhwa, and Mr. Mudit Jain, and our student coordinators, Ms. Harshita, Ms. Ishita Singh, Ms. Isha Singh, Mr. Utkarsh Srivastava, Mr. Arijit Srivastava, and all the volunteers and members for their meticulous planning and execution of this conference. Your dedication has ensured that this Induslex Confluence was both insightful and impactful. As we conclude, let us take forward the knowledge shared today and use it to build a future where legal expertise continues to drive ethical and sustainable legal practices. Once again, I thank you all for all your time and your presence here with your wisdom. We look forward to more of such interactions in the future. Thank you. Thank you all. Have a nice day.
Thank you, everyone. I would like the panel members to please proceed with the lunch. Thank you, audience, for being so patient and for your wonderful questions.
Oof.